Illinois v. Gates, Supreme Court, 1983. Justice Rehnquist delivered the opinion of the court. Respondents Lance and Susan Gates were indicted for violation of state drug laws after police officers, executing a search warrant, discovered marijuana and other contraband in their automobile and home. Prior to trial, the Gateses moved to suppress evidence seized during this search. The Illinois Supreme Court affirmed the decisions of lower state courts, granting the motion. It held that the affidavit submitted in support of the state's application for a warrant to search the Gates' property was inadequate under this court's decisions in Aguilar v. Texas and Spinelli v. United States. 1. We turn to the question presented in the state's original petition for certiorari, which requires us to decide whether respondents' rights under the 4th and 14th Amendments were violated by the search of their car and house. The chronological statement of events usually introduces the issues at stake. Bloomingdale, Illinois is a suburb of Chicago located in DuPage County. On May 3, 1978, the Bloomingdale Police Department received by mail an anonymous handwritten letter which reads as follows. This letter is to inform you that you have a couple in your town who strictly make their living on selling drugs. They are Sue and Lance Gates. They live on Greenway, off Bloomingdale Road, in the condominiums. Most of their buys are done in Florida. Sue, his wife, drives their car to Florida, where she leaves it to be loaded up with drugs. Then Lance flies down and drives it back. Sue flies back after she drops the car off in Florida. May 3rd, she is driving down there again, and Lance will be flying down in a few days to drive it back. At the time Lance drives the car back, he has the trunk loaded with over $100,000 in drugs. Presently, they have over $100,000 worth of drugs in their basement. They brag about the fact that they never have to work. They make their entire living on pushers. I guarantee if you watch them carefully, you will make a big catch. They are friends with some big drug dealers who visit their house often. The letter was referred by the chief of police of the Bloomingdale Police Department to Detective Matter, who decided to pursue the tip. Matter learned from the office of the Illinois Secretary of State that an Illinois driver's license had been issued to one Lance Gates residing at a stated address in Bloomingdale. He contacted a confidential informant whose examination of certain financial records revealed a more recent address for the Gateses, and he also learned from a police officer assigned to O'Hare Airport that L. Gates had made a reservation on Eastern Airlines Flight 245 to West Palm Beach, Florida, scheduled to depart from Chicago on May 5th at 4:15 p.m. Matter then made arrangements with an agent of the Drug Enforcement Administration for surveillance of the May 5 Eastern Airlines flight. The agent later reported to Matter that Gates had boarded the flight and that federal agents in Florida had observed him arrive in West Palm Beach and take a taxi to the nearby Holiday Inn. They also reported that Gates went to a room registered to one Susan Gates, and that, at 7 a.m. the next morning, Gates and an unidentified woman left the motel in a Mercury bearing Illinois license plates and drove northbound on an interstate frequently used by travelers to the Chicago area. In addition, the DEA agent informed Matter that the license plate number on the Mercury registered to a Hornet station wagon owned by Gates. The agent also advised Matter that the driving time between West Palm Beach and Bloomingdale was approximately 22 to 24 hours. Matter signed an affidavit setting forth the foregoing facts and submitted it to a judge of the Circuit Court of DuPage County, together with a copy of the anonymous letter. The judge of that court thereupon issued a search warrant for the Gates' residence and for their automobile. The judge, in deciding to issue the warrant, could have determined that the modus operandi of the Gateses has been substantially corroborated. As the anonymous letter predicted, Lance Gates had flown from Chicago to West Palm Beach late in the afternoon of May 5th, had checked into a hotel room registered in the name of his wife, and at 7 a.m. the following morning had headed north accompanied by an unidentified woman out of West Palm Beach on an interstate highway used by travelers from South Florida to Chicago in an automobile bearing a license plate issued to him. At 5:15 a.m. on March 7th, only 36 hours after he had flown out of Chicago, Lance Gates and his wife returned to their home in Bloomingdale, driving the car in which they had left West Palm Beach some 22 hours earlier. The Bloomingdale police were awaiting them, searched the trunk of the Mercury, and uncovered approximately 350 pounds of marijuana. A search of the Gates' home revealed marijuana, weapons, and other contraband. The Illinois Circuit Court ordered suppression of all these items on the ground that the affidavit submitted to the circuit judge failed to support the necessary determination of probable cause to believe that the Gates' automobile and home contained the contraband in question. This decision was affirmed in turn by the Illinois Appellate Court and by a divided vote of the Supreme Court of Illinois. The Illinois Supreme Court concluded, and we are inclined to agree, that, standing alone, the anonymous letter sent to the Bloomingdale Police Department would not provide the basis for a magistrate's determination that there was probable cause to believe contraband would be found in the Gates' car and home. The letter provides virtually nothing from which one might conclude that its author is either honest or his information reliable. Likewise, the letter gives absolutely no indication of the basis for the writer's predictions regarding the Gates' criminal activities. Something more was required then before a magistrate could conclude that there was probable cause to believe that contraband would be found in the Gates' home and car. The Illinois Supreme Court also properly recognized that Detective Mader's affidavit might be capable of supplementing the anonymous letter with information sufficient to permit a determination of probable cause. In holding that the affidavit in fact did not contain sufficient additional information to sustain a determination of probable cause, the Illinois Supreme Court applied a two-pronged test derived from our decision in Spinelli v. United States. We agree with the Illinois Supreme Court that an informant's veracity, reliability, and basis of knowledge are all highly relevant in determining the value of his report. We do not agree, however, that these elements should be understood as entirely separate and independent requirements to be rigidly exacted in every case, which the opinion of the Supreme Court of Illinois would imply. Rather, as detailed below, they should be understood simply as closely intertwined issues that may usefully illuminate the common sense practical question whether there is probable cause to believe that contraband or evidence is located in a particular place. 2. This totality of the circumstances approach is far more consistent with our prior treatment of probable cause than is any rigid demand that specific tests be satisfied by every informant's tip. Perhaps the central teaching of our decisions bearing on the probable cause standard is that it is a practical, non-technical conception. In dealing with probable cause, as the very name implies, we deal with probabilities. These are not technical. They are the factual and practical considerations of everyday life on which reasonable and prudent men, not legal technicians, act. As our language indicates, we intend neither a rigid compartmentalization of the inquiries to an informant's veracity, reliability, and basis of knowledge, nor that these inquiries be elaborate exegeses of an informant's tip. That's a weird sentence. As our language indicates, we intended neither a rigid compartmentalization of the inquiries into an informant's veracity, reliability, and basis of knowledge, nor that these inquiries be elaborate exegeses of any informant's tip. Rather, we required only that some facts bearing on two particular issues be provided to the magistrate. This process does not deal with hard certainties, but with probabilities. Long before the law of probabilities was articulated as such, practical people formulated certain common-sense conclusions about human behavior. Jurors, as fact-finders, are permitted to do the same, and so are law enforcement officers. Finally, the evidence thus collected must be seen and weighed not in terms of library analysis by scholars, but as understood by those versed in the field of law enforcement. As these comments illustrate, probable cause is a fluid concept, turning on the assessment of probabilities in particular factual contexts, not readily or even usefully reduced to a neat set of legal rules. Informant's tips doubtless come in many shapes and sizes from many different types of persons. Moreover, the two-pronged test directs analysis into two largely independent channels: the informant's veracity or reliability, and his basis of knowledge. There are persuasive arguments against according these two elements such independent status. Instead, they are better understood as relevant considerations in the totality of the circumstances analysis that traditionally has guided probable cause determinations. A deficiency in one may be compensated for in determining the overall reliability of a tip by a strong showing as to the other, or by some other indicia of reliability. If, for example, a particular informant is known for the unusual reliability of his predictions of certain types of criminal activities in a locality, his failure in a particular case to thoroughly set forth the basis of his knowledge surely should not serve as an absolute bar to a finding of probable cause based on his tip. Likewise, if an unquestionably honest citizen comes forward with a report of criminal activity, which, if fabricated, would subject him to criminal liability, we have found rigorous scrutiny on the basis of his knowledge unnecessary. Conversely, even if we entertain some doubt as to an informant's motives, his explicit and detailed description of alleged wrongdoing, along with a statement that the event was observed firsthand, entitle his tip to greater weight than might otherwise be the case. Unlike a totality of the circumstances analysis, which permits a balanced assessment of the relative weights of all the various indicia of reliability and unreliability, attending an informant's tip, the two-prong test has encouraged an excessively technical dissection of informant's tips, with undue attention being focused on isolated issues that cannot sensibly be divorced from the other facts presented to the magistrate. Finally, the direction taken by decisions following Spinelli poorly serves the most basic function of any government, to provide for the security of the individual and of his property. The strictures that inevitably accompany the two-prong test cannot avoid seriously impeding the task of law enforcement. If, as the Illinois Supreme Court apparently thought, that test must be rigorously applied in every case, anonymous tips seldom would be of greatly diminished value in police work. Ordinary citizens, like ordinary witnesses, generally do not provide extensive recitations of the basis of their everyday observations. Likewise, as the Illinois Supreme Court observed in this case, the veracity of persons supplying anonymous tips is by hypothesis largely unknown and unknowable. As a result, anonymous tips seldom could survive a rigorous application of either of the Spinelli prongs. Yet, such tips, particularly when supplemented by independent police investigation, frequently contribute to the solution of otherwise perfect crimes. While a conscientious assessment of the basis for crediting such tips is required by the Fourth Amendment, a standard that leaves virtually no place for anonymous citizen informants is not. For all these reasons, we conclude that it is wiser to abandon the two-prong test established by our decisions in Aguilar and Spinelli. In its place, we reaffirm the totality of the circumstances analysis that traditionally has informed probable cause determinations. The task of the issuing magistrate is simply to make a practical, common-sense decision whether, given all the circumstance set forth in the affidavit before him, including the veracity and basis of knowledge of persons supplying hearsay information, there is a fair probability that contraband or evidence of a crime will be found in a particular place. And the duty of a reviewing court is simply to ensure that the magistrate had a substantial basis for concluding that probable cause existed. We are convinced that this flexible, easily applied standard will better achieve the accommodation of public and private interests that the Fourth Amendment requires than does the approach that had developed from Aguilar and Spinelli. Our earlier cases illustrate the limits beyond which a magistrate may not venture in issuing a warrant. A sworn statement of an affiant that he has cause to suspect and does believe that liquor illegally brought into the United States is located on certain premises will not do. An affidavit must provide the magistrate with a substantial basis for determining the existence of probable cause, and a wholly conclusory statement fails to meet this requirement. An officer's statement that affiants have received reliable information from a credible person and believe that heroin is stored in a home is likewise inadequate. This is a mere conclusory statement that gives the magistrate virtually no basis at all for making a judgment regarding probable cause. Sufficient information must be presented to the magistrate to allow that official to determine probable cause. His action cannot be a mere ratification of the bare conclusions of others. In order to ensure that such an abdication of the magistrate's duty does not occur, courts must continue to conscientiously review the sufficiency of affidavits on which warrants are issued. But when we move beyond the bare-bones affidavits, this area simply does not lend itself to a prescribed set of rules. Instead, the flexible, common-sense standard articulated better serves the purposes of the Fourth Amendment's probable cause requirement. 3. Our decisions applying the totality of the circumstances analysis outlined above have consistently recognized the value of corroboration of details of an informant's tip by independent police work. Likewise, we recognize the probative value of corroborative efforts of police officials. In addition, the magistrate could rely on the anonymous letter, which had been corroborated in major part by Mader's efforts. The corroboration of the letter's predictions that the Gates' car would be in Florida, that Lance Gates would fly to Florida in the next day or so, and that he would drive the car north toward Bloomingdale all indicated, albeit not with certainty, the informant's other assertions also were true. Because an informant is right about some things, he is more probably right about other facts, including the claim regarding the Gates' illegal activity. This may well not be the type of reliability or veracity necessary to satisfy some views of the veracity prong of Spinelli, but we think it suffices for the practical, common-sense judgment called for in making a probable cause determination. It is enough for purposes of assessing probable cause that corroboration through other sources of information reduce the chances of a reckless or prevaricating tale, thus providing a substantial basis for crediting the hearsay. This is perfectly reasonable. As discussed previously, probable cause requires only a probability or substantial chance of criminal activity, not an actual showing of such activity. By hypothesis, therefore, innocent behavior frequently will provide the basis for a showing of probable cause. To require otherwise would be to sub silentio impose a drastically more rigorous definition of probable cause than the security of our citizens demands. We think the Illinois court attempted a too rigid classification of the types of conduct that may be relied upon in seeking to demonstrate probable cause. In making a determination of probable cause, the relevant inquiry is not whether particular conduct is innocent or guilty, but the degree of suspicion that attaches to particular types of non-criminal acts. Finally, the anonymous letter contained a range of details relating not just to easily obtained facts and conditions existing at the time of the tip, but to future actions of third parties ordinarily not easily predicted. The letter writer's accurate information as to the travel plans of each of the Gateses was of a character likely obtained only from the Gateses themselves, or from someone familiar with their not entirely ordinary travel plans. If the informant had access to accurate information of this type, a magistrate could properly conclude that it was not unlikely that he also had access to reliable information of the Gates' alleged illegal activities. Of course, the Gates' travel plans might have been learned from a talkative neighbor or travel agent. Under the two-pronged test developed from Spinelli, the character of the details in the anonymous letter might well not permit a sufficiently clear inference regarding the letter writer's basis of knowledge. But as discussed previously, probable cause does not demand the certainty we associate with formal trials. It is enough that there was a fair probability that the writer of the anonymous letter had obtained his entire story either from the Gateses or someone they trusted. And corroboration of major portions of the letter's predictions provides just this probability. It is apparent, therefore, that the judge issuing the warrant had a substantial basis for concluding that probable cause to search the Gates' home and car existed.